Can an unprotected email cost you a few million? This is Stuff Employers Should Know.
Welcome to Stuff Employers Should Know, proudly brought to you by LabourNet, management's ultimate HR solution.
Hey, and welcome to the show. It's Yasser Yaslak and Ismail, audio producer and host for the day. I am joined by National Information Compliance Empire Manager, and of course, a friend of the show, Samantha Walker, as well as Sasha Tulshi, who is an information compliance consultant here at LabourNet. And today they're going to be taking us through a very, very interesting case regarding a very costly unprotected email that has been sent out.
Hi, I'm Samantha Walker, and in studio today I have
Sasha Tulshi.
And today we are going to be discussing the dangers of email. So Sasha, there's been some interesting developments in this space, in particular the cybercrime space. Do you maybe just want to touch on really what cybercrime is and how does this position itself in our country?
Yes, Sam. So cybercrime is the illegal usage of any communication device to commit or facilitate in committing any illegal act. So cybercrimes are mostly committed using computers and computer networks, and usually the target group are individuals, business groups, or even governments. And obviously with any cybercrime, there's got to be, the main or focal point of it. And with any cybercrime, the primary effect is financial gain. So cybercrime can include many different types of profit-driven criminal activity, such as ransomware attacks, email and internet fraud, and even identity fraud.
Okay, so this is really almost like a new crime space that's been emerging over a number of years. If I think back, some of our biggest fears was a Trojan getting into your system. And now it's as easy as stealing a mail, and so much can necessarily go wrong. And I think that's so perfectly highlighted in the case that we're going to be discussing today. And the case of Horden and versus Edward Nathan Sonnenbergs, which is ENS, the biggest law firm in Africa, if I'm not mistaken. They had a massive case now in the High Court, and it's really shed a lot of light on this area and our responsibilities as corporates to data privacy as well as personal information. So I know that the case touches on and turns specifically around BEC. Do you want to maybe take us through what that is and how it really linked into this case?
So business email compromise is a type of cybercrime in which an attacker uses phishing or social engineering tactics to gain access to a company or even an individual's email accounts, and in doing so, it enables them to steal sensitive information such as financial information or even personal data. In South Africa, we have noticed that in the recent number of years, there's been a huge increase in the commission of cyber-related crimes, as you pointed out, Sam, but specifically business email compromise. Now, the most vulnerable to a business email compromise are conveyancing firms, more especially their clients where transactions involve electronic transfers of large amounts of money. And the fact that there's a daily flow of payment transactions between clients and conveyancing firms, as a result, they have become common targets for email interceptions, cyber fraud, and identity theft.
So in terms of this case, Horden versus ENS, really we saw the entire case turn around this business email compromise. And what I think is so important to necessarily point out in this matter is that it was not ENS's emails that were hacked. It was the individual who was meant to make payment to them that was hacked. So I think that's a very niche point that needs to be remembered as we're discussing the background of the case necessarily. But you want to maybe take us through some of that factual background and how it played out in court?
Sure, Sam. So with the ENS case, as you pointed out, and I must stress that this is one of the most largest prominent law firms in Africa. So in this particular case, Howden purchased a property from a third party who had then in turn appointed ENS as the conveyancer. And as part of the transaction of their purchase and sale, Howden was provided with ENS's bank account details in a PDF format via email from ENS's conveyancing department. What had then happened was Howden made payment of 5.5 million rand into what she thought was ENS's bank account. Now, what had actually happened was cybercriminals had intercepted certain email communications between Howden and the ENS conveyancing department. And in doing so, they had managed to manipulate the PDF bank details to reflect the cybercriminal's bank account instead of ENS's.
Should I even ask whether that PDF was password protected?
No, it was not.
And therein lies our first issue, I'm sure. So in this case, the bank account details were changed to reflect that of obviously the fraudsters and not of ENS, where this 5.5 million was paid into the account. As I mentioned earlier, it was actually the plaintiff, Ms. Howden's account, that was hacked, not ENS's, even though ENS has been held liable in this matter. And I think what's so interesting is that this is the first sort of in this area that we've seen a delictual claim for pure economic loss from an omission. So this is where ENS is being held accountable for not doing something. This is not because they did something, it's because they didn't do something. And I think if we look on really what the case turned on is this legal duty of care that they keep harping on about. Can you take us into really what Ms. Howden's argument was in terms of the legal duty of care that ENS owed to her?
So, Sam, in the normal purchase and sale transactions, obviously the conveyancer owes a legal duty of care towards both parties that they are dealing with, purchaser and seller, to ensure that in all of their communications with them, they highlight to them the dangers of certain cyber crimes, or if there's any red flags or risks involved in certain transactions, that they bring it to their attention. And what had happened in Howden's case was that they had failed, or rather, this was their omission. In their legal duty of care towards her, they had failed to firstly properly inform her of what business email compromise is. They failed to let her know, listen, such a thing exists. You need to be careful in your transactions of payments and monies that you're making to us. And in addition to that, they failed to even warn her about or even advise of the steps she could have taken to verify their banking details. You'll notice in law practice, a lot of conveyancing firms that we have experience with, we know that usually there's always a disclaimer in the email advising us that they'll never change their banking details and advise us via email. And there's also a disclaimer of some sort that states that, listen, if you are making payment to us, make sure you contact us to confirm our banking details, which in this case ENS had failed to do. And the last thing that they had failed to do was implement adequate security measures.
So the moment you say that sentence, my ears tend to perk up. And I think at this point of where we are in the show, a whole bunch of people are wondering why two POPI experts are discussing cybercrime. And really, this is when things start linking in, because data protection is what we should be striving for. In my opinion, POPI is just a stepping stone on that data protection journey, but we need to be implementing best practice. We need to go even further than POPI, in my personal opinion. And when we're hearing that the court has ruled that they failed to implement adequate security measures, POPI literally requires us to implement adequate security measures. So it is almost a word for word that the judge has taken from the POPI Act. So I think at this point, it's relevant to mention that POPI was not in force when this case happened. So that's why we're not really seeing a big information regulator case, but a court case, because this plaintiff took them on for damages, the loss of that 5.5 million that went into someone else's account. But we can see that the court's sort of opinion of data protection and personal information is directly aligned with POPI, and that POPI is going to start playing more and more in these sort of cases. Now, I understand that was really how they failed, but what did they say her part in this was in terms of ENS? What was ENS's version that they put forward in terms of her negligence?
So here's where it comes to a super interesting part, or one of many in this case, and if I can say so, this honestly just made me want to laugh at the nonsense that ENS's counsel decided to put in a high court. So one of the things that they said was that they felt that Howden should have taken appropriate steps to make sure that her transactions were safe, to make sure that the banking details were correct, and that she should have done so by either confirming with them or even confirming with her banking institution when she was going ahead with the payment. On the flip side, Howden blamed ENS for her loss. And then again, she brings in the duty of care that they should have warned her and brought to her attention the dangers of BEC. But the most important, or the highlight that we can take out of this, is that because ENS's reputation is that of a prominent law firm, Howden felt that she was in safe hands, and she trusted the information that was communicated to her by the ENS conveyancing department.
I think that's such an important point, and that word you've just pointed out, trust. It's something that the court turned on quite a bit throughout the entire judgment, is that the plaintiff placed her trust in ENS, and there is no reason why she shouldn't have done that. So if you are a corporate, or even like us here at LabourNet, we're in a position of trust to our clients. We need to ensure that we are protecting them. They are not sophisticated individuals. Well, in this particular case, the plaintiff was a retired elderly woman who was a social activist. This is not sort of their forte area. So us as corporates have to take on the responsibility to protect those we interact with. And I think that even then interlinks into the expert witnesses that were brought by the plaintiff, who showed the court how easily a PDF being emailed can be intercepted and changed. And secondly, provided solutions that ENS could have imposed, I believe, for less than 2,000 Rand a month. So do you want to maybe take us to some of the solutions they suggested?
So there were a number of expert witnesses, both for ENS and Howden, that came into play in this case. And one of the expert witnesses went to the extent of preparing a demo which illustrated one solution to ENS's problem. That being them having a secure portal for the transmission of sensitive communications to be used in conjunction with a two-factor authentication, which, had they used, would have been an effective way of avoiding compromise incidents. And some of the expert witnesses also touched on a lot of technologies that they stressed the importance of and felt that ENS was expected to utilize to secure their email communications. Because, I mean, you're such a prominent law firm. Surely you must be aware of all of these, technologies available. So some of the technologies that were mentioned by the expert witnesses were Sender Policy Framework. Now, this is a mail authentication method designed to detect forging sender addresses during the delivery of the mail.
So that's almost the spoofed addresses, like we saw in this case with the R and the I switched around in the email address that went to her.
Yeah, that was it. And, to the common user, a layperson's not going to look. The first thing that a person's going to look at when they get an email is not 100% who it came from or the subject. They want to read the contents of the email.
And that's actually something that the court confirmed and got ENS's, the counsel for the plaintiff got ENS's witnesses to admit that no reasonable person would have noticed the I and the R switched around.
100%. Like we realized with this case, ENS, their counsel were all over the place when it came to trying to dig and find some point to sort of weaken Howden's case. And going back to the expert witnesses, a lot of ENS's expert witnesses, they actually messed up what they had said. And under cross-examination, they actually agreed with the fact that ENS could have utilized all of these technologies.
Which was in contradiction of their witness statements they had previously submitted to the court. So we had contradicting versions from all of the witnesses before the court. And I think one of the very interesting things is the Sender Policy Framework you spoke about. It was quite clearly demonstrated that if that had been turned on, this wouldn't have happened. They would have been alerted to that spoof email. And throughout their expert witnesses, they fumbled and they mumbled to determine whether it was on or off. And ultimately, only one of their witnesses said that if it wasn't on, or even if it was on, it still wouldn't have aided in this situation. So I think that's also very important to note, that we need to have these small back-end things in place. Otherwise, things like this happen.
Sure. And you know what? their entire cross-examination and testimonies it was like almost like a circus, and I wish I had a front row seat to that, because one of the expert witnesses also brought in a technology called domain-based message authentication reporting and conformance protocol. It's quite an earful, but he felt that if they had also utilized that, then they could have definitely avoided a situation like the one they had currently found themselves in.
And I think the judge illustrated that quite nicely in the judgment, where he said ENS owed at least a general duty of care to a purchaser of a property. In this case, the plaintiff. ENS, as Ms. Horden contends, had control over the way in which its bank account details were conveyed to her. So I think that's quite interesting. They were the ones in control of how we communicate our banking details. It chose to do this by way of unprotected email, attaching its bank account details as a PDF document, which could have easily been manipulated as the evidence clearly established. So such a simple thing of putting a password on this document would have prevented all of this from happening. And I think that is also another area that we need to touch on, is often when I start speaking about data protection, clients tell me, well, I don't have the money for that. It's going to cost me millions for all these fancy systems. And you know what? You can literally spend and spend and spend in this area. There's so many softwares and systems you can get. But the thing is, it doesn't need to be expensive. Putting a password on a PDF doesn't cost you absolutely anything. It's going to cost you 5 seconds of your time necessarily, and prevents a 5.5 million rand court case. So using email, using secure channels, most of us operate off Teams or even business WhatsApp. That's end-to-end encrypted. That's much safer to transmit documents than it is to email. So we can really protect our clients against this with what we have in our businesses currently. We don't have to run out and now buy new fancy things. It's just about the way in what we currently have.
Totally agree with you, Sam. Just coming back to your point on that, in the demo that one of the expert witnesses had prepared, which was really great, he touched on the domain-based message authentication. He even went to the extent of breaking down the financial aspect of what it would have cost ENS to actually put in place or utilize this software. And he broke it down to such an extent that he found that they could have eliminated so many costs. They would have only incurred costs for actually, the actual installation of the software. And he was of the opinion that this, what it would have cost them was like a drop in the ocean compared to what their IT budget was.
100%. It was less than 2,000 Rand that this could have been fixed for. And a prominent law firm like ENS, whose hourly rate is far above 2,000 Rand, could have had this paid with 1 hour of work necessarily in a month by one attorney when they have so many. Another thing for me that was very, very interesting in this matter is that the expert witnesses of Ms. Horden pulled up ENS's acceptable use policy. Now, for us in the data protection space, this is not something new. Most companies have an acceptable use policy in place, and even if you use a third-party IT service provider, they've most likely put one in place. It's the most basic IT document we generally see, and everyone has one. Now, what was interesting is ENS had an acceptable use policy at the time of this case, and in that policy, it stipulated that confidential and sensitive information must be sent, obviously, via PDF, that is password protected. But even in their own policy, they acknowledge that email is not safe. Did they actually follow their own policy? Can you touch on a bit of that for us?
Well, they clearly didn't, because now they're sitting at this point. The interesting part about this was after the whole crime had taken place with the fraudulent banking details being sent, in communication sent to Horden after that, they sent through their investment mandate and their acceptable use policy to her after the crime had taken place, which means, and under cross-examination, their conveyancing secretary who had, I believe, sent these emails to Horden, she agreed with Horden's counsel in that I could have sent that investment mandate and acceptable use policy. In addition to that, I could have also sent, our policies on the risks of BEC to her prior to me sending her the banking details, or at least in every single communication that I made with her, which I failed to do.
Exactly. And the council even got her to admit that those warnings about the phishing and the BEC was of absolute no use because she had already transferred the money.
But here's the funny part. I like to say it's the funny part, is ENS is convincing the employee went to the extent of under cross-examination stating that she had no idea that sending banking details via PDF was so high risk. And that brings into question what was ENS doing in terms of training their employees about all of these cybercrimes and risks related to, data protection and privacy.
Exactly. And if we look at during the cross-examination of all of the witnesses that ENS brought, when they were asked, did they go through training during onboarding about cybersecurity? Apparently, none of them could remember whether it was contained in the induction or not. And that links straight into Poppy, because in Poppy, we require training. So this highlights another big issue for us. We need to train our staff. An acceptable use policy was in place. It had been implemented, but it was not followed. And the staff didn't actually even know about it or how to password protect, etc. And in this case, that means all ENS did was achieve sort of paper compliance by putting that policy in there. And even for our clients, you can walk the entire Poppy journey with us and implement all of the policies we tell you to. But if your people are not following that and you're not monitoring it, those policies are not even worth the pieces of paper they're written on. And that's exactly what happened here. Their data protection system was not being enforced. People weren't following it. And that's when we saw the drop come in. So it's very important that whatever policies you do have in place, we make sure that our staff is actually following it.
100%. So they don't go into court and say they can't remember if they got trained or not.
Exactly. And even at LabourNet, we're ISO compliant. And one of the first questions one of our ISO auditors asked a staff member in Cape Town was, what policies are you familiar with? What policies do you have in place? So this is a very necessary thing across the data protection industry. And I think this then brings us to my favorite part of this case. And the part that shocked me the most in terms of ENS's attitude and their council's attitude towards this case and the court, and also what made me very happy in terms of how the judge reacted. So I want to speak about the personal information that ENS stole off Ms. Horden's computer. Ms. Horden's computer was copied and a mirror was given to ENS to investigate. Is that correct?
Yes, that's correct.
And then when they were going through this, they were doing so in order to investigate whether hacking had happened and at what point or how the hackers had got in. During this process, ENS, contradictory to an agreement between the attorneys, removed a whole bunch of information off Ms. Horden's computer. And Ms. Horden actually testified to this in court. The records that they took included a Vodacom cell phone record from January 2019 to December 2019, a Nedbank corporate saver interim statement, an email between Ms. Horden and her lawyer about her divorce, her actual divorce settlement, which was confidential and concealed, and now also breaches her agreement with her husband not to expose that. On top of that, they had her RMB investment portfolio statement, 2011 email about her tax affairs. They had a document of her Alexander Forbes investment advice agreement dated 1 April 2014. An email dated 27 May 2014 that arises out of one of the foundations the plaintiff worked with, the Solon Foundation, which is a very private Swiss foundation who funds us in this country for education in rural areas. They also found two further Solon Foundation documents, as well as the Memorandum of Incorporation for a non-profit called Compassionate Friends, which the plaintiff joined as a grief counselor after the loss of her child. None of this information was relevant in the court case, and I think the fact that they put it in the trial bundle, I don't think there's any other words besides it was despicable, and their respect for her and her privacy was thrown out the window completely. And in this case, it's actually what cost them the costs. So when the judge was deciding what costs to award against ENS, they decided to give punitive costs, being attorney and own client costs. That's the highest scale you can give. That's really reserved for a hiding when you have not listened. And if we look at it, the judge said that ordinarily, costs follow the result. The plaintiff seeks a punitive cost order. Attorney and client costs have frequently been awarded against parties for conduct which is vexatious and an abusive legal process, even though there is no intention to be vexatious. As counsel for Ms. Horden pointed out, the plaintiff's right to privacy was breached by including numerous documents in the trial bundle which no relevance to the issues in the case. It is inexcusable for the defendant to have done so. Nowhere and at no stage was there, however, an explanation or apology offered to the plaintiff by any of their witnesses for including it in the trial bundle, breaching the agreement not to take it, and actually displaying it as well. So really what we saw from that is the judge awarded punitive costs just on the basis of that action of stealing that personal information and making it now public, because any court document is public. They have literally placed her sensitive personal information in the public domain. The judge went so far to say he's not even considering the other two grounds of costs. This is enough. And first time I read this judgment, I started having heart attacks and saying the information regulator is going to come. We're going to see big fines. This is how it works out. And that's when I realized the act was not in play yet. Unfortunately, our law does not act retrospectively. However, the act of them putting it in the trial bundle, depending on when that happened, may be an issue for the information regulator. Is there anything you want to add on this point?
Yes, Sam. So I think this was the cherry on top for this entire case. And you notice in a lot of the media articles being published, a lot of the focus is obviously on the dangers of business email compromise. But a lot of them have failed to even pick up on this part about the plaintiff's privacy, that there was a breach in terms of this. And the worst part about this, and it might almost sound like bashing the defendant, ENS, but I mean, it is what it is, and the judge had a great go at them, is that they, and it was quoted in the judgment, they made her relive the most traumatic part of her life, which was losing her child. And putting all of that information out there just put her in such a traumatizing state of mind. And in addition to that, you now want to come back and tell her that she should have been so much more careful with, the banking details that they gave her in her transaction with them. So the judge was really not happy with ENS, their counsel, and the way they approached this entire case.
I think we see that evidently throughout the entire judgment, the language that is used. It is
harsh.
It is very harsh, and it is evident that the judge really had an issue with ENS's behavior and their attitude towards this as well. If we look at this, we have a retired social activist who has lost a child and just went through a divorce, and we pulled that all up and put it in the public domain because you couldn't put on a simple piece of technology that would have prevented this. So on top of all of this, ENS has had to they're going to have to pay the 5.5 million back. They also are going to have to pay punitive costs, all of her costs. And that includes costs of 2 counsel and costs of 2 expert witnesses. So I think this bill is going to be quite heavy. If we look at it, just the interest on this case is probably at about 2.5 million now. So all in all, I think ENS is probably looking at about a 15 million rand hiding for this. And I don't think that's, I think they've got away with nothing almost if we look at their size and especially their attitude and how they really didn't care for her right to privacy, or the fact that this was their fault. They could have protected against it.
100%. And also let's not forget the fact that in addition to the great costs that were awarded in her favor, ENS is now going to realize that they are going to be suffering severe financial loss and loss in terms of reputational damage, because I know as a client, I wouldn't want to be dealing with a firm that's been dragged into the media for a case that infringed on a person's privacy, and also where they, as such a prominent organization, did not even have proper safety and security measures in place to protect information. So we can see in the coming years that what's really important from this case to take is the financial loss and reputational damage that organizations can, will bear rather in terms of not being compliant with not just POPI, but other legislation that does exist that says you need to take a step back and look at the way you're operating. Make sure you have everything in place.
100%. I think the costs of any breaches, fines, court cases, reputational damage, all of these things are going to far outweigh anything that you would pay to have good data protection. So in this case, it's evident that something as simple as password protecting can solve an issue. You don't have to, spend thousands. Do what you can with what you have in your environment, and just make sure your people are well trained. I think that's the biggest thing. Once we start training our people and they become aware of these small little things, we will see this happen less and less and less. But from what we've also seen here at LabourNet is there is quite a bit of a stigma still around data protection, and people don't want to train their staff. They just want this problem to go away. And I'm actually happy this case has happened, because I think it's brought to light the seriousness of data protection all over the world, not just here, but that us as South Africans need to start getting serious about it as well.
That's a great point, Sam. And I think on that note, a lot of people are now going to take POPI seriously and no longer look at us as the POPI people, because with all of the case law that's now coming into play and the fact that, our judges and courts are taking this extremely seriously, it now calls for organizations to put in the effort and also take this seriously as well.
I agree. I hope everyone listening does take it seriously and does put measures in place, even if they are simple measures that really can be achieved. Because I think that's the only way we're going to move forward in this space, is once everyone is playing at the same level, or at least doing something. But thank you very much, Sasha, for discussing this case with me. It was very, very interesting. I know I thoroughly enjoyed this case. I think everyone in the office is avoiding me because I keep wanting to discuss it. So I'm very happy I got to come and get this all out here. So thank you for listening and joining us, and we'll see you next time.
And that sums up today's show. Thank you so much, ladies, for being here and obviously shedding some light on a very, very serious and interesting case. Of course, it does display the importance of sticking to regulations and, of course, the importance of the protection of personal information. If you'd like to get in touch with our POPI team, you can fire an email off to poppy@labournet.com. And if you want to get in touch with us at Stuff Employers Should Know, or if you have any episode suggestions, or if you have any questions relative to our previous episodes, please fire off an email to sesk@labournet.com, and we'll be sure to get back to you. Thanks so much for tuning in.
Stuff Employers Should Know was proudly brought to you by LabourNet, management's ultimate HR solution. For more episodes from Stuff Employers Should Know, go to Apple Podcasts, Google Podcasts, or wherever you play your favorite shows. Case law or statutes referenced in the podcast are current at the time of recording.